Hello, everyone. Welcome to the Trademark Like a Boss show. I am Radiance Harris, founder and managing attorney of Radiance IP Law, and I help emerging businesses protect, monetize, and grow profitable brands with trademarks. Today, we are going to be talking about the difference between trademarks and copyrights. So if you are here watching live, say hello in the comments, drop where you are watching from. Also, if you have any questions about trademarks or copyrights, drop them in the comments as well so that I can answer them during this show. And if you're watching the replay, drop the hashtag replay so that I know that you watched it at a later date. So I wanted to get on here and break down the difference between trademarks and copyright because people always get them messed up or confused. So I just wanted to set the record straight and break down the simplest form what the difference between a trademark and a copyright is. So for starters, a trademark protects your brand. So it can protect your business name, your brand name, your product or service name, your logo, your event name, your podcast name, anything that is meant to be used as a source identifier in the marketplace. So it's a way to distinguish your products and services from those of a competitor, okay? Copyright, on the other hand, it protects original works of authorship fixed in tangible form. So it protects content. So any content that you are creating and sharing out there in the marketplace would be considered copyright or protected by copyright. So think, for example, websites, videos such as this, the podcast recordings that you're doing, the training manuals that you've created, the book that you've just written or completed. Maybe you do comic books. That's also subject to copyright protection. Photographs that you take. Anything that, again, is the tangible expression, original works is what we call original works of expression in tangible form would be subject to copyright. So when you see, for example, like the TM designation or the registration symbol, which is the R with the circle, those designate trademarks. So the TM is just a designation that anyone can use. It doesn't carry any legal weight whatsoever. So anybody can technically just use the TM designation and slap it on something. Carries no legal weight. But the registration symbol, which is the R with a circle around it, carries lots of legal weight. And only trademark owners can use that. So if you've secured a US federal trademark registration from the US Patent and Trademark Office, you can use the registration symbol. That is the only time you can use it. You cannot use it when you started the trademark process. You can only use it once you've actually completed the registration process. On the flip side, the C with the circle around it is for use when you are claiming copyright protection in something or copyright ownership in something. The way essentially copyright works is whoever creates the content owns the content unless there is something in writing to the contrary. So copyright automatically sticks upon creation of the content. And so when you slap, you can slap the copyright notice on there. People do on their websites, they might include it in a book. You can certainly do that, regardless of whether or not you actually use that copyright designation or the symbol, you still have copyright ownership. It's just a way to signify to third parties that you are claiming copyright ownership in the works. Similarly, if you find photographs or content out there, just because it doesn't have the copyright notice does not mean that someone does not actually own copyright in that content. And it's important to note that when you're using the copyright notice, you do want to use the year that the actual copyright was created. So you don't want to keep updating the year as you keep making changes. You want to use the original year. Like you might see on a website, the copyright notice, 2021, Radiance IP Law, LLC, all rights reserved. You want to use the original date that the content was created. You don't want to keep updating that date. So on the flip side with trademarks, the way trademarks work is that if you start using a name without US federal trademark registration protection, so let's say you've been in business for 3 years, you did not secure a trademark from the USPTO, you have at a minimum what's called common law trademark rights. So common law trademark rights are limited geographically to basically where you're located. So even if you have a business where you are working with clients nationwide, if you are headquartered in Maryland, I'm in Maryland. So if I'm headquartered in Maryland, but I didn't secure a US federal trademark registration, my trademark rights are limited to Maryland because that is where I'm headquartered. So technically, a competitor could open up a competing business in all the other 49 states because I did not secure trademark rights. So trademark rights do incur or do start to stick once you start using a name, but your rights are very limited to where you're located geographically. So once you then pursue the US federal trademark registration process, now you have the exclusive right to use your business nationwide across all 50 United States. So that's a difference. I wanted to break down clearly like the difference between trademarks and like how you actually protect them, and then copyrights and how you protect them. So to just clarify what the difference is, so with copyright, ownership automatically sticks upon the creation of the work. And there isn't much else you need to do, with the caveat that it is to your benefit to secure copyright protection from the US Copyright Office. So to secure copyright registration from the US Copyright Office as additional insurance for any copyrighted materials that is widely distributed and circulated and is making you a lot of money or has the potential to make you a lot of money. So like, for example, if you have books that you've written, it would be beneficial to you to go and secure copyright registration from the US Copyright Office for those books because they're going to be widely distributed, could get a lot of hands. Someone could, illegally upload it and download it on their website without your permission. And so having a US copyright registration is a prerequisite to filing any kind of trademark infringement claims, issuing any DMCA notices and things like that. So it's very important to get copyright registrations for certain content that has a lot of value, could be widely distributed, could potentially be stolen. But again, copyright sticks once you create the content. Flip side, trademarks, you have rights based on use, provided that you're not infringing on someone else who already has prior rights to you. But just by virtue of using a name, you have what's called common law trademark rights, but it's very limited to where you're located geographically, and someone else in any of the other jurisdictions or regions throughout the United States can steal your name, logo, taglines, what have you, and you wouldn't have any recourse. So there are tremendous benefits to securing a trademark registration for your business name, brand names, product and service names, logos, taglines, things like that, to ensure that you remain the rightful owner. So in both instances, both trademark and copyright, they protect the owner from theft. So it ensures that he or she is the only one who can lawfully use and monetize the brand or content that they own. Okay, so that is the purpose of a trademark and a copyright, is to protect the owner from theft and to ensure that they are the only ones who can use and monetize their brand, their content, and any third parties who wish to use their brand or content would need to seek permission from the owner. So those are important differences that I wanted to highlight. Also, something worth highlighting is that in a lot of cases, most small business owners have multiple things that they can and should protect. So a lot of small businesses, they start up, then they might decide to go and get one trademark, and then they think that they're good. But most small businesses have what we call an intellectual property portfolio. So they have multiple intellectual property assets that they can and should protect and leverage. So a lot of times businesses have multiple trademarks. A lot of times they have tons of copyright because they've created so much valuable content. And then there's trade secrets. Also, we're not really going into trade secrets today, but I would say just about all small businesses, no matter what industry you're in, have those three things. You've got trademarks, you've got copyright, and you've got trade secrets. Trade secrets are basically anything that's meant to be proprietary in your business. It can be business records, client records, business processes, anything that is your secret sauce in business is considered a trade secret. So in most cases, your business has all three of these things. Not all businesses, though, have patents. So I don't even handle patents, so I'm not even going to speak on that. But patents is another form of intellectual property, in addition to those three that I mentioned, where you would seek protection for. But again, that's only for certain product-based, invented-based businesses. So hopefully that is a clear breakdown of those two very important areas in intellectual property. Another thing I wanted to highlight is that, so if you have a logo, for example, you have a logo, here are some things that I want you to keep in mind. So most small businesses go and they hire someone to draft or create, design, whatever, their logo. And with that, think about this. So you're hiring a third party, you're paying them to design your logo. But they forget to have work made for hire agreements in place, which would assign the intellectual property. Because as I mentioned, whoever creates the content owns the content unless there is something in writing to the contrary. So there are a lot of small businesses out here who don't actually own their logos because they did not get the intellectual property or the copyright assigned in the logo to the actual business. And so it's important to note, one, the importance of that, making sure that all IP is transferred to your business and that ownership. Secondly, the fact that a logo actually has inherently two forms of intellectual property. So you have the copyright protection because it's an original expression in tangible form in the logo, like meaning someone drew that out or designed it out. So you actually have copyright protection in that. And you have trademark protection in that logo as well if it's being used as a source identifier and being used in connection with your products or services. So there are actually dual protection in a logo. So if you have a logo, you should definitely look into getting protection for getting copyright registration for it and potentially a trademark, not potentially, but definitely trademark registration for that logo as well. The beauty of this all, if you are interested in learning more about the difference, actually in the back of my book, Trademark Like a Boss. Oh, that's not correct. Sorry. Let me show you the correct link. A copy of my book, Trademark Like a Boss, has at the back of it a chart that actually breaks down all the different forms of intellectual property. And there's actually an audit in the back too. And it's all included in my Trademark Like a Boss book. So if you don't have the copy of the book, definitely get a copy of it. You can see in the back of the book, I include a chart and an audit for you to actually go through and identify your own intellectual property, your own trademarks, your own copyright, your own trade secrets and patents and all that stuff. And it's all in the back of my book, which is like $24.97. So it is a steal. And of course, if you do want to explore further your own trademarks and copyright, I would be delighted to speak with you. You can absolutely schedule a trademark strategy call with me, and we can do a deep dive into your trademark brand protection strategy. Okay, so thank you guys for tuning in today. I hope I have broken down for you clearly the difference between trademark and copyright, and hopefully you have a better understanding about the difference between the two. Okay, so let me see if there's any questions. I don't think I saw any questions. Okay, no questions. But if you happen to come up with a question, feel free to drop it in the comments, and I will respond at my convenience. But thank you for tuning in today, guys. I hope you learned a lot. Until next week, take care. Bye.